So we're going to just introduce the people who participate in creating this series. And again, I'm Kit Needham with Assistant Dean for Entrepreneurship and Director of Project Olympus, which is the startup incubator for Carnegie Mellon University. So we help students, faculty, alum, staff help with any type of an idea at any stage. And the idea is to get you product market fit and so you can get funded. So we put this together with my counterpart at Pitt, Rhonda.
Hi, thank you, Kit. I am Rhonda Schultz. I'm the director of Pitt's Big Idea Center. We are the hub for student innovation and entrepreneurship, and we work with students from freshman to postdoc, even residents at UPMC who have an entrepreneurial interest, idea, and take them from early exploration all the way through launch and even some funding in their first investment if necessary.
So Stephanie.
Hi, I'm Stephanie Dangle. I'm a professor of practice at Pitt Law School, and I teach a variety of courses at the intersection of law and innovation. Probably the most relevant to this is the commercializing new technologies course I teach. I see many lawyers I know on this call, as well as a few former students and current students. So I'm really excited to be able to learn from them.
Okay, and Reed.
Hey everybody, I'm Reed McManigle. I work in the Technology Transfer Office at Carnegie Mellon. So our office manages university-owned IP at CMU. So I can talk about the IP policies at CMU. My particular role in the office is that I'm the startup mentor. So when inventors say that they're thinking about doing a startup, I get called in to help them connect with resources within CMU and in the outside community. Much earlier in my career, I worked at the Technology Transfer Office at Pitt, so I have some sense of how things work there, but it's old information, so I can try to answer questions there, but I'm not the expert anymore there.
So Shamal, I would probably start with Rhonda and she can get you connected. Just mention this too. So now I'd like to turn this over to David Lehman, who is sort of our legal side of the partnership in presenting the Start Smart series. And David, you can introduce yourself and your team.
Well, thank you. And thank you everybody for joining us this evening. We're going to focus this evening on intellectual property and different ways to protect your intellectual property. And a couple of my colleagues are here as well. So let me introduce first George Dickos. George, you want to introduce yourself?
Thanks, David. Yeah, I'm George Dickos. I'm an intellectual property partner with K&L Gates. David and I started at the firm a few decades ago now. My practice is really focused on all aspects of IP. Early on, we started the group in the firm, and so we had to do all different aspects from litigation to patent trademark prosecution, licensing. Right now, what I do mostly is a lot of deal work relating to intellectual property. And as I say, litigation avoidance. You're trying to help people do what they want to do without being stopped, or to stop others from doing what they don't want them to do without going to litigation, if possible. It's funny, we had a situation today where they started off with the call with the client, CEO and the VP of the client saying, we got to sue these guys. These guys got us knocked off of a big website, let's just say. We think improperly based on a patent assertion. And basically, if they didn't relent in that, we would sue them for competition, patent misuse, antitrust violations, all kind of stuff. But we said let's just dig a little deeper here. And here we found out that they relented, and we are now back on the site. So, rather than spending a lot of time and money in litigation, a lot of distractions, we were able to resolve this by properly asserting the patent that we were accused of infringing is not valid. And we, I guess, convinced them of that. So again, a lot of what I do is counseling, serving as, in essence, chief IP counsel for various clients of the firm.
Well, thanks, George. Yeah, I hate to see us avoid litigation because there's no money in that, but that's beside the point. Lorraine, you want to introduce yourself?
Sure. I'm Lorraine Murray. I'm also a partner in the intellectual property group. and I focus my practice on patent law and patent portfolio management. So my background is mechanical engineering, and I work regularly with inventors and then the patent office, and act sort of as the liaison in between to try to get those inventions patentable and build IP portfolios.
Thanks, Lauren.
Mhm.
And I'm pleased to report that I am not a patent lawyer. I've worked with startup companies, and I help provide sort of guidance on IP related issues and strategy, but I have the benefit of not being a patent lawyer. So what we want to do today is talk about sort of IP as it relates to startups. And I thought what we would do is sort of start with the types of intellectual property protection, sort of overviews of those, so that's sort of the basics, so we at least know what we're talking about when we're talking about IP. Then we could talk a little bit about the ownership of IP and ways to and who owns IP, and maybe in that context we'll also talk a bit about issues related special to universities, both in classroom and licensing technology out of the university and how it relates. And then we can talk a bit about how to search for IP records, and then talk a bit about strategy, and we'll throw some other things in there as well. You should feel free to interrupt us. It's much better if we talk about things that you're interested in than what we're interested in. So you should not wait till the end. You should please feel free to ask questions along the way, and we'll address them. And we're happy to go off on other tangents if you like. So there's patents, trademarks, trade secrets, copyrights, all these wonderful things, and we should probably spend a moment making sure we understand what those things are. And the good news from my colleagues is I did not window who I was going to ask to talk about what, so they're just going to. It's like a little quiz. This is great. How much fun is that? Lauren, let me start with you on trade secrets. Can I ask you to spend a moment sort of describing for folks what trade secrets are, and why they should care?
Sure. Well, trade secrets are anything that is a secret and that you take steps to protect as a secret. So oftentimes it is related to technology. It might be a technological improvement, but it's not limited to that. It can also encompass things like client lists and know-how. So it spans technical and non-technical. And what's important about trade secrets is that it is in fact a secret, and that you take steps to keep it a secret. If someone else independently figures out how your trade secret, then the trade secret is lost. So in that sense, it's different from patents, where you have the protection of the patent through the generally 20-year term. But with trade secrets, as soon as somebody else can reverse engineer it or discovers it independently, then the trade secret is lost.
So it's in perpetuity as long as you keep it secret. And one of the most important things is keep getting people like to sign NDAs if you tell them about if you're going to disclose it to them, because you got to show that you've kept it secret. Right?
Exactly. So you have to take the steps to prove that you have treated it as trade secret, as confidential information, things like NDAs, and even beyond that, I mean, just limiting access to it. Things like the Coca-Cola formula is a famous example, and they say not one single person knows the formula. So they take all kinds of steps to protect it by, locking it up and keeping it in a way that people can't find it.
So the good news is that as we'll talk about, but for the startups, trade secrets is sort of is attractive. There's no filing. You just have it. You don't have to file with the Patent and Trademark Office. It's not public. Nobody knows about it. Like when the patent you file, which we're going to talk about in a moment. It's in perpetuity, but you got to keep it secret. Which is really important. And the other thing is, as Loren said, if it's independently created, you don't have protection for that. Unlike, for example, patents where people, if they independently, they still can't do it, practice it, even if they independently, if it infringes the patent. George is going to yell at me about the way I said that, not very precisely, but that gets the point.
No, I'm going
That's-
to throw something else out if I may.
Mhm.
We deal with this counseling clients every day, and you ask clients, do you have any trade secrets? Oh no, we don't have any. Nothing we have is secret. I strongly disagree with that. I start with the proposition that everything you have is secret, unless you published it somewhere. Ponder that for a second. It's really important, and most startups don't do this. I know entrepreneurs are very busy, energetic people doing a lot of things, but taking time to think about your trade secrets, write them down, categorize them, as Loren said, use protective measures to keep them secret, and certainly agreement-wise. You really want to have a catalog of your trade secrets because you do have them and they are valuable.
Okay, no. Any question on trade secrets? I want to compare and contrast that with patents next. So, George, let me go to you to talk a little bit about what patents are, if that's okay.
Sure. A lot of people think they know what patents are as well, and most people don't. A patent doesn't give you the right to do anything. It's an exclusionary right. It's a contract between you and the government that basically says if you disclose your invention and it's new and non-obvious and useful, and you claim it properly, and and the government can grant you a patent to exclude others from practicing the claimed invention. It's really critical to appreciate that patents have metes and bounds on them. That's what is claimed in the patent. Just like a deed to real property has metes and bounds. If start this point, go this direction, that direction, and you own what's inside that. Patent is the same concept. It is property. It's intellectual property. So if you meet the standards of patentability, you can exclude others from coming into that property, just like we can exclude people from coming into your real estate property. It's just so important that people understand that it doesn't give you the right to make anything. It is possible, certainly, to get a patent on something that infringes someone else's patent. Okay, it's not a get out of jail free card just because you patented something. You have to independently patent and claim your invention and get around other people's patents. So it's a complicated area, but that's why you have experts to help you navigate these waters. It's not for the faint of heart. And I'm sure a lot of people think, oh, patents are so expensive, and they are, relatively speaking. It costs thousands of dollars to get patents. Loren can talk more about that as we go on. But it's really important to think about these as assets of your enterprise that can have, as CFU has learned, $1 billion value.
And so, and give us just a better sense of of what the requirements are for a patent.
Yeah, we'll drill down a little bit. I said it has to be new, non-obvious, and useful. Most anything you do is going to be useful. That's an easy one to meet. New means it's not part of the prior art exactly. And not obvious means it wouldn't be obvious to do what you're claiming in view of the prior art. So what's in the prior art? It's stuff that came before your application, basically. Stuff that's in the public domain, other people's patents, things that are published. That's all part of the prior art. Now, in the US, you've got basically a 1-year grace period for if you disclose something, you have a year to file a patent application on it in the US. Many foreign countries don't give you that grace period. So it's really important before you disclose anything publicly, put something in a grant request, publish, obviously a university issue there, but to at least get a provisional patent application on file that describes your invention and sets it forth as being yours. We can talk about the distinction between provisional and non-provisional patent applications later, but it's really important to record your ownership, put your stake on the moon that this is what your technology is, and then that gives you options later.
Now would probably be a good time to talk about the provisional, as long as we're here, provisional versus a non-provisional patent. I love that name, non-provisional. I keep wanting to use word like permanent or real or whatever, but non-provisional seems to be the best I can come up with.
Provisional patent applications are relatively a new creation of the law. It enables people to file what you consider as a disclosure document saying that I've got this idea. We'll file what's called this provisional patent application. It does not necessarily have to have the claims. Remember, I said the claims are the most important part of the patent because that define the metes and bounds of the invention. You don't have to have that in a provisional application. But you do have to fully describe the invention in the provisional application because 12 years after they're filed, 12 months rather, poof, they go away. They evaporate. So you have to file, as Dave said, the non-provisional application within that year period with the full disclosure, with full set of claims, other required documents. Now, here's another thing that people sometimes have trouble remembering. The disclosure in the non-provisional application is only as good as that in the provisional application. There is no lessened disclosure requirement. So if you want support for the earlier filing date of the provisional, you have to disclose it in the provisional. People thought you could just send something in the back of an envelope and that's it. You can do that, but that's all you have disclosure for. So we really try and create robust provisional applications. It costs a little more money up front, but you're sure you're describing the invention as fulsome as possible at that time. You can elaborate more perhaps as the year ensues and you develop the technology more. But you need to think of provisionals, take them seriously. Now, do sometimes we have to file them the next day when the disclosure is about to occur? You bet. In the university environment, obviously, there's strong incentive to publish, and there's some tension there. But it's still important to file something before it's published. Maybe even file the paper before it's published as a provisional patent application. It's better than not doing it. Trust me.
Thanks, Reed. Do you want to weigh in on that one?
Yeah, just jump in, and you're right, in the academic environment, there's very strong pressure to publish. So what we tell our researchers is just be aware of this and the timing of it. We don't want to slow you down. Keep us in mind when you send up a manuscript for review, send us an invention disclosure. Keep us informed when that manuscript's got to get published. We can file a provisional application to beat that deadline, but don't wait until the day it's going to be published to tell us, hey, could you file this? Or go to a conference and people come up and throng you and say, do you have a patent on it? And say, what? So just think about this process while you're preparing for publication. Do them in parallel and we won't hold you up.
So thank you. And so the part of the point that I hear is that it's important for startups to understand and think about early on the type of protection that they're going to pursue. So I've learned so far, which is if you're going to seek trade secret or try to maintain trade secret, you better sure as heck keep it confidential, because the minute you disclose it without an NDA or a provisional without an NDA, we're going to waive it. And similarly, if I publish it or I disclose it, I may be waiving a patent protection, at least outside the U.S. and if I do it within a year in the U.S. as well. And I can avoid that by filing a provisional patent application, at least on the patent side, but not the trade secret side. Again, the point I want to make is it's essential to figure out early on. You don't have to do these things, but it's important for our startups to understand that they need to think hard early on about what kind of approach they'd like to take with respect to IP, because you can find yourself in a situation where you waive those rights down the road by actions you've taken. So I always talk about people developing an IP strategy or a roadmap early on, just so you're not making mistakes that you can't unwind, which is what we've seen in the past. Maybe we should circle back to the we'll come back to the potential benefits to provisionals a little bit, but let's round up other IP protection. So we talked about trade secret, we talked about patent. I've heard there's something called a copyright. Loren, what the hell is a copyright?
So copyright protects works of authorship, things that are fixed in a what we call a tangible medium. So words that are written on a page in a book or a different type of literary work, paintings, sculptures, photography. Oftentimes in the tech space, we see it with computer programs and software. So it is a creative medium, but it has to be fixed and written down. And what you're actually protecting is how it shows up in that tangible medium, not the idea of it.
So it's protecting the expression
Yes.
itself.
Mm-hmm.
And so somebody, you're protecting for somebody can't copy it, but they can certainly, but I can do one can perform it, and one just can't recreate it after looking at it. Right.
Right.
So it's the idea versus expression dichotomy.
Yes. Yes. And it is the act of copying it that is what you're prohibited from doing. So, you can't make photocopies of it, or you can't, forward a newsletter, for example, to other people, because in that sense, it's been copied and sent to other people and shared.
The old days, people used to worry about, so one of the things I've always heard is it's difficult to prove that it was copied. So in the days when people used to write software, they used to keep little footprints or something in it, in a way that if somebody copied, you'd be able to tell because there was something unique in it that it would have had to been copied, because nobody would possibly have put that in there.
Right, some sort of signature or identifier that.
Right. Right. Atlas used to have fake links, I think, or something like that. I used to hear. But anyways, but the idea is to somehow put things in it so you can, because part of the problem in enforcing copyrights is proving that somebody actually copied it, right? I think.
Right.
So, and do you have to register the copyright?
You don't have to register it, but you do have to register it before you enforce it. And registration is pretty straightforward. So it's really as simple as sending it into the copyright office to say this is copyrighted. But the copyright and the ownership right vests when you create it. So there's no requirement, like with a patent, you have to have that filing date. But with copyright, it's the ownership right exists as soon as you have created it and fixed it in that tangible expression.
So everybody puts these little C's with copyright on everything. Do you have to do that? And what's the benefit of it? It
provides notice. So there's certainly a benefit to doing that. And it provides notice that you own it. And it would definitely be advisable to do that and to say, I own this and this is the date that it was created. Usually there's a year associated with it. So we generally do advise that our clients add the Circle C and indicate that it's copyrighted. And the registration can happen later. It doesn't have to happen at the time that you add that Circle C.
Okay. Mm-hmm. All right. So that's a copyright. Then there's these trademarks.
Read.
Yeah. Read. Sorry.
I don't know if you're planning on covering this later, but just to drive the point home, software is protected by copyright. Depending on the nature of the software, it can also be protected by patent. So at CMU, our template license, when we're licensing university IP, contemplates both. We're licensing you patent rights, we're licensing you copyright rights. And then depending on the situation, we take one or the other out. Sometimes we're only licensing copyright. We actually do more licenses each year for copyright code than we do for patented technology, which may not be obvious.
That's not obvious. Yeah, interesting.
And part of that is because we license some code over and over and over, non-exclusively. So people have a choice, like we can write our own code. We don't have to take these lines of code that were written at CMU, but they actually were written at CMU, and CMU knows what they're doing. It's been tested, it's been deployed by many, many other people. It's a build versus buy situation for them. We're just going to pay CMU this license fee, take this code that's already been tested, and just go ahead and use it. We don't have to write it ourselves. But they could by the same token, have written their own software code. It's a build versus buy decision for them.
Got it. Okay. All right, so that's copyright. Trademarks, George?
Trademarks are kind of a different animal. Trademarks are fundamentally source identifiers. They signify one's brand of something, whether it's a computer or a phone or a watch or a lamp, or it just signifies your brand of goods or services. There are such things as service marks, which are marks applied to identify the source of services. So it can get very complicated. For example, in the case of McDonald's on the side of a building is a service mark for restaurant services. McDonald's on a wrapper of a hamburger is a trademark for goods, the hamburger. And McDonald's Inc. is a trade name for the business enterprise, the McDonald's Corporation. So these three things kind of overlap, and it really depends on how you use the marks. They're really intended to help the public by identifying a consistent source of goods or services. Problems arise, of course, where people try and have their trademark be too close to someone else's trademark. That's where you have infringement situations occur. Also, I should mention there are different levels of strength of trademarks, from arbitrary or fanciful marks to suggestive marks to descriptive marks to generic marks, which aren't protectable. The law is not going to let people take commonly used words out of common parlance for those purposes. That's why Apple's a great trademark for computers. It's not a trademark for apples.
And just to for the practical matter, the little sign that people put on, like for trademark and R's, and what's that all?
Yeah, good question, Dave. Circle R means that a trademark is registered. You have to go through the application process, the approval process, the potential opposition process in the Patent and Trademark Office in the US. And if you successfully pass all those things and prove actual use of the mark in interstate commerce, they'll give you the registration, you put the circle R. You want to use a circle R when you're entitled to it, because that's, again, like copyrights, provides a notice function and removes some defenses against the possible infringers might use. It's also important to recognize that you can use the TM really whatever you want. You're allowed to use TM. All that means is you're claiming trademark rights. There's no universal convention, universal laws that apply to the use of TM. We think it is a best practice to, in connection with one's goods or services, to use the TM, even if it's not registered. It shows a level of sophistication, frankly, and it lets people know that you're taking this seriously.
Cool. So when I think about IP, I think about two different ways of things about defense and offense. And one is as offensively, which is anyway, it's to protect yourself and your company against third parties, maybe defense, against third parties infringing your IP, and you're creating an asset for your company. So if I have a trademark, or I have a patent, or I have a copyright, or a trade secret, that is a protectable asset of the company, and one that I can use to ward off, to distinguish my company from others. That's creating an asset. The other way I think about IP is making sure that I'm not infringing somebody else's IP, and making sure, and sort of thinking through whether I'm infringing somebody else's patent, trademark, or it's a little more so on a little less so on the trade secret side, but that can happen as well. And we'll talk about that in a moment, clearing it. But one of the things we've talked about is, and you sort of touched on this, which is making sure you're not infringing somebody else's. And so the best way to do that, I think, is to, at least on the patent and the trademark side, is to do some searching, and to see what's out there, right? And it's a question as to how much you do, and how in depth you do, and how you go about it. And I know, Reed, you have you do some of that sort of strategically at the university, and so maybe I should question you about how the university's approach to what searching you do, and then maybe we'll ask Lauren to talk a little bit about how they, as a practical matter, how we do it.
Yeah, I'm interested in hearing Lauren and George's perspective on it because it seems like our attitude towards it has changed in recent years. Back in the day, I had like a number of law school interns through a program that we ran with Stephanie, where they would do patent searches. And now we've quit doing that. And in some sense, I think based on legal counsel telling us it's better that you don't know what's out there. Because if you know something, you have to disclose it to the patent office, and then they can use that to deny your patent. But so you're sort of trusting that the patent office isn't going to find it. So I'm really interested in what Lauren and George have to say, because my thought was like, why waste money on filing a patent if you could do a little bit of searching and find out that you're already blocked?
I think you're right, Reed. You know, it just want to put their head in the sand or want to know what's out there. It really kind of comes down to that. So I think some degree of searching is a good idea. And if it's thrown in the, you know, in the prior art, then you can't patent it. But you're not going to waste time and years of your life trying to patent it. Well, and searching, we believe, gives you one a sense of what's in the prior art, so you can craft the patent application around it. You kind of know what you're going to have to be faced with down the road, so you can keep that in mind as you're drafting the application. Write a better application. Yeah, candidly, we think the balance comes out in favor of searching, but cost is a factor, and sometimes timing. It takes a little while to do some searching, and it costs some revenues to some resources to do searching. So oftentimes nowadays people are trying to do things more and more inexpensively, and they don't do searching. But we think it's still a good idea if you can do it, spend a little bit of money, a little bit of time. We still think it's the best practice if possible to do it.
And another factor is how well the inventors know the art and the landscape at the outset. I mean, sometimes the inventors really already have a great understanding of what came before them and what they're building on. And, in that case, the patent search, I think just to clarify, we're talking about a patentability search here. And I know David had sort of was talking about infringement searching too, which is a different type of searching, but a patentability search or something you would do before you file a patent application. We generally do recommend it, but there's times, as George mentioned, where it doesn't happen because of time constraints, money constraints, or in the circumstances where the inventors are, really cutting edge. They 100% know what is out there in the public domain that's been published. And the exercise of searching isn't really necessary in that instance either.
And so I would say my attitude is it's sort of like you wouldn't do your PhD thesis without doing a literature search to find out what's out there. So that sort of puts it on the inventors, the researchers to do this, because patent attorneys are expensive. If you go to a law firm and say, would you do a patent search for us? Like, they could quickly run up lots and lots of hours. Where you could have done a lot of that homework yourself, and you're probably going to understand the technical jargon and field better than the attorney. On the other hand, just even if you do the most complete patent search ever, you can't find everything, because there's a window of time where there can be things filed that aren't yet publicly viewable. It's still prior art against you because it's filed before you, but you literally cannot find it because it's not yet public. So you can never have 100% certainty that you found everything.
It's also worth noting, I mean, prior art can exist anywhere in the world, not just in the US and not just in English. We see that all the time where the prior art that's cited against your patent application is, a translation of something that's in a foreign language. So, to Reed's point, you can't find everything out there, or even if you found it, you wouldn't be able to understand it because you don't speak that language. So, it's not foolproof, but there is some certainty, and it's an investment to file a patent application and to prosecute a patent application. And knowing from the get-go that you did a bit of diligence before you, put in more time and money is usually worthwhile.
And Kit, you want to mention the librarian's name at CMU who helps people at CMU? And
Yeah, I was actually going to put it in chat, but I think this is more efficient with the way I type. We have a librarian that has developed expertise in how to search not only the U.S. patent database, but as well as the international. So you can find him on our domain experts page, I think under the legal, and the same as Matt Marstello, and he's in the Wien Library. You contact him, he will ask you to do a little bit of preparation, then you show up with your computer, and we'll have, for example, everything's done by Boolean keyword search. So what are the different words that you can use to look? And he will just literally sit there with you to help you at least get a really good idea of what other prior art is out there. So not sure it's quite the same as a patent attorney, but on the other hand, it's free.
Something to be said for that. Lauren, can you distinguish the infringement? You talked about the difference between an infringement search and a patentability search.
Right, and that comes up in the offensive versus defensive conversation. But with respect to an infringement search, if you are releasing a product, a service, you want to make sure you're not infringing other people's IP. And to see if you're infringing other people's patents, you would need to do a search to see what patents are out there. In that case, you look at the claims of the patent, and it's a highly technical analysis. I would say it's more technical than a patentability search, where you're evaluating what's disclosed to a person of skill in the art. In this case, you want to know what the boundary of those claims are, and also checking to see, of course, if the patent is enforced, if it's and so it's a bit of a more sophisticated analysis. It's certainly something that non-lawyers can start off in doing, but something that's generally better suited for a lawyer for a final input, because in that case you want to make sure before you again spend all of your resources and time and money to implement this product and get it into manufacturing, that you're not going to run afoul of somebody else's IP.
So let me, and I guess I want to emphasize that, which is it clearly is a balance, but I'll give you the war story because that's what we do. And in the last few months, we represented a company that was all set to buy another company. We represent company X, who's going to buy company Y. And it turns out that company Y had a very large company, Fortune 100 company, suing it for patent infringement. And there was no way that a company, AA or our client, could get comfortable acquiring the company with that patent infringement claim against it, and we walked away from the deal. And so the founders of that company and the owners lost out on a lot of money because it was a patent infringement claim against them. The merits of it, you can get into it, but they will never be clear. It's, in my view, important to at least consider a patent search and determine whether or not what you're doing is going to infringe a third party's IP. It can be as short as the principals and inventors or founders going to the patent trademark website and looking it up and seeing whether things are even close, and deciding at that point whether you should have a lawyer look at it. But just nosing around to see if there's anything out there that sticks. And I take Reed's point about you're not going to get everything, but I don't think you should let the enemy be the perfect be the enemy of the good here, or the other way around. And at least look around and probe around and see what's out there. Is sort of my thinking on that one with startup companies on the infringement side.
The universe of what you're looking at is smaller than from a patentability perspective, where it's, again, anywhere in the world, anything that predates your filing, because you're looking at well, assuming you're going to be working in the US, it's US only patents that are just, US specific, because patent law is territorial in that sense. So you want to look at US patents that are within, issued and still enforced. Patents are subject to generally a 20-year patent term. So after that, everything that's in a patent is dedicated to the public.
And what about trademark? Is it similar for a trademark search?
It's still a good idea to do that. It's good to know what's out there. And and to go back for a second to your acquisition example, that was a severe case where there's an infringement suit filed and people had to walk away from the deal. Other cases, we've had acquisition transactions where they will have us do something. If the technology is really important, they'll have us evaluate the quality of the patents. And to Reed's point, we can usually find something that we've negotiated 8-digit purchase price reductions because of finding potential flaws in the patent estate. Again, on the trademark side, it's a little bit easier to search and see what's out there. You can do online searches in the PTO, and frankly, Google searching is another good trademark searching tool.
Okay.
Question. From a startup perspective, you're a small startup and suddenly you think that you have IP, a patent or a provisional patent that protects you. And suddenly you have a large corporation who said no, and they're suing you. Isn't there now sort of an opportunity to have your litigation funded if you really have a valid claim so that you can protect your IP?
Well, if you're on the offensive, which is you're suing a third party for patent infringement, and so there's a big payout, then having it funded is quite feasible.
Okay.
Assuming it's valid and all that good stuff, right? I mean, there's lots of patent funders out there, litigation funders who would like to, or happy to basically take that on. I mean, lawyers sometimes do things like contingent fee. These are people that are other people that are willing to fund that kind of litigation. It's a little harder on the defense side because there's no pot of gold at the end.
Right.
You can buy insurance, but it's very expensive.
Very expensive. Yeah. But certainly, you're absolutely right. If you find yourself in a spot where you're a startup company, there's a big company that's infringing your IP, there are ways to fund that litigation. So that potential litigation against the big party, because I mean, there's patent litigation, to give people a sense of it, is next to antitrust the most expensive kind of litigation there is. I mean, it's millions and millions and millions of dollars. It's second only to antitrust, and it goes on for literally a decade. But sometimes it's worth it. Okay. Cool. Let me shift. That deals with sort of the basics of IP. I want to shift a little bit to IP ownership, unless somebody wants to go in a different direction. Because we covered sort of protecting it, not infringing somebody else's, but I do think it's important to touch on, make sure you own the IP, and in the first place. And that comes from several places. One is making sure that when you're looking around at your founders, make sure that they actually own it. And so they don't have don't have some invention assignment to some third party, that they haven't that sometimes people come in and they say, okay, I'm starting a company, here's the business plan, here's my idea, et cetera. I said, where are you working? They say, I'm working for XYZ Corporation. I said, well, unfortunately, you don't own it. XYZ Corporation owns it because you did it while you were on company time or whatever. And they had so that's step one. When you and your founders ought to look around and make sure that you actually own what you're creating. A perfect example is universities where university professors don't own it. The university does, and we license it out. I don't know if you want to speak to that, Reed, at that point, or the process from licensing the technology out of the university.
I think first I'm going to talk about ownership policies.
Please.
So, as David said, if you're working for a company, you've signed an employment agreement and you've said, anything I invent while I'm an employee is owned by the company. At the university, there's a more nuanced approach, and it comes down to individual university policies. And CMU's policy says that CMU institutionally owns IP if that IP came out of funded research. So typically faculty PhD students are paid on research grants. We own their IP at CMU. But if you are doing things at CMU that wasn't based on funded research, you can own it personally. And the line isn't about status, whether you're a student or faculty, it's about funding. So faculty at CMU doing things on the side own it personally. So every time our office gets an invention disclosure, the first thing we have to do is figure out, does CMU own this or do the individuals own it? Whereas if you're in a company, they just own it. And many universities, they just own it. But at CMU, it's like we have to look at each individual situation, figure out who owns this one. And one of the factors that comes in at some universities is, did you make substantial use of university resources? And there's a policy definition of what substantial use of university resources is. And at some universities, if you have made substantial use for university resources, then the university owns it. So there's gradations of this question within different institutions.
What about students? We're in class together in a class project, and they create IP as students. Who owns it?
At CMU, they are not funded to be in that class. It's the opposite. They're paying to be in that class. So at CMU, they own that IP.
Right.
The challenging thing at CMU is a professor has funding and uses it to pay students on the side as work study students, perhaps. Then it's work for hire. But if the same students are working on it in a project course, then they own it. So sometimes we have students in both categories, and we have to go through it like, we own this student's work, we don't own that student's work. If we want to get unity of ownership to do a license, we need to get those students to assign their ownership. These ones we already own because it's work for hire, and it becomes this complicated mess just to get unity where we can license all of our rights to somebody else.
I want to just chime in with a typical situation we see, that many of the students go through what I call capstone courses, where they work on a project with the team. And at the end of the semester or whatever, that there could often be one or two out of the team of 5, for example, that say, you know what, we think this is a really cool idea. We want to take what we developed in class and we want to start, and they'll start working with us on exploring creating a company. Does it have good, when we find product market fit and a feasible business model? So the question is, what do we do about the other 3 who participated in the working on the project? And so I can repeat what I've heard, but if one of you IP lawyers want to take on exactly who can do what with what, that would be great.
George,
I'll jump in first. It really depends on the facts of the situation. Who did what? If they're all real inventors, and you know, we're just touching the surface on a lot of these intellectual property concepts, but an important one that we didn't mention previously is that only a true inventor can apply for a patent. You can't have derived it from someone and then be a true inventor that way. So you got to look at the facts and say, were they all 5 inventors of what ultimately is a claimed invention? If they are, in CMU, you got to go to Reed's example and ferret out those rights and potentially get assignments from the 3 to the other 2 to proceed. Otherwise,
I heard that all 5 then can do anything. They are equal owners.
without an assignment, inventors are co-owners. Yes.
Okay. And so
Yeah, that's why you want to get the assignment into the 2 or into an entity formed by the 2.
and they don't even have to disclose to the others that this is what I'm going to do with it. So ideally, the situation we tell the people, if most of the students, the other 3, for example, could care less. Secondly, I have to tell you, most of the IP that is created in these classes ends up not being the final product at all. You would never file a patent on it too. So but if you can get the student while they're there, your classmates, and saying, would you be willing to assign whatever it is over to us? But even if they don't, you're entitled to pursue it yourself.
You are, but you're always at risk that the others will get wind of this and they'll pursue it too, or license someone else to pursue it. So,
And as importantly, which, yeah, and what you're doing is leaving open, right, somebody later making a claim that they own part of that IP.
yeah, that's why for the cost of a few beers, it's good to get an assignment.
Yeah, yeah. So what we can say is in exchange for you assigning it to us, you can say, we will acknowledge you on the website or whatever the whole thing is, that your contribution to this, so that you can point to it, you can put it on your resume. We can write you a letter, which you could use when you're using in your job searches, thanking you for your participation. I had one, it was a PhD who actually gave $50. And also a letter of appreciation or expression for the contribution. So there's a kind of the debate of what is the consideration? Is the consideration the grade, or is it the consideration? But to be on the safe side, she said, I can afford this money to pay something in exchange. But the point is, try to do it as quickly as possible before everybody leaves, because tracking down.
Yeah,
other-
before they leave or before it's worth $1 billion.
Yeah.
Actually, a question for you, George. Suppose there are 5 students and they all equally contribute are inventors on the invention, and you want to file a patent on that invention, and all 5 are inventors. Who don't you need all 5 on the patent?
You have to name all the true inventors. And if you intentionally don't name the correct inventors, the patent's invalid.
And you have to name them. Do they all have to be?
You have to name them all.
They don't all need to sign it, but they all need to be named.
Dealing with uncooperative inventors is a tricky thing. You want them to sign, certainly.
Right.
I don't know if you could actually make someone sign.
But your point's well taken, which is that it's really important point, which is that when you file a patent, you have to name all the inventors. And I've been in situations where people have not done that. And then later it was used as a third party, used as an opportunity to invalidate the patent because not all the inventors were originally named.
Well, the converse used to occur a lot in the olden days. People would always put their boss on the patents too.
That's interesting. Yeah.
And it's just as invalid. If it's intentionally incorrect, it's invalid.
That's interesting, and particularly in the university setting. Interesting.
Yeah.
Okay. Got it. Cool. So the inventor's got to be right. Cool. Excellent. Okay. Let me go back to IP ownership for 1 second. About invention assignments and how important they are. So we've talked about making sure that you're not subject to an invention assignment to a third party, but it's pretty critical that we get invention assignments from folks into the new company as they create, and that goes to formation and in the future. And I don't know, Lorraine, you want to spend a moment talking about why I need that invention assignment, and in particular, independent contractors? Do you know that? Are you familiar with that? Invention. If I just hire a contractor who owns the IP.
Right. So, well, in all instances, and there's a lot of different circumstances, you might be working with an independent contractor, you might be working with a consulting firm. Oftentimes there's joint ventures, people partner with universities or with certain nonprofits. So it can come up in a lot of different settings, and the facts are always different. But the main takeaway is from the get-go, you want to figure out who owns it and get the assignments signed and then recorded. So it's hard to give a blanket, this is the case here, because it just depends. I mean, generally though, when you work for an employer, the employer owns it. There's usually, that's part of your employment agreement. And the same with when companies contract, they generally say, we're hiring these consultants, but whatever they create on this project, we own. So you want to have those kinds of things set up before you start working, and just make sure that they are in place, because, and for all of the people who may be involved, because what we often see is a team of 5, 10 or more people, and you don't know at the outset who's going to be contributing to the invention. And again, it comes down to who is an inventor. Did they make a contribution to the invention itself? Not the routine engineers, not those who implement it, but those who came up with the concept of the invention. And it's hard to predict. So you want to have the agreements in place before, so that whoever ends up involved has an obligation to assign their rights, and then the following through and getting them actually assigned.
Yeah, so and let me emphasize that, because things ebb and flow, and I see different things coming up at different times. And at the moment, one of the hot button items that I'm seeing in due diligence, both with respect to financing and selling, is making sure that there's proper IP invention assignments by all third parties. And that goes to every employee who's contributed to the IP, every independent contractor that's contributed to the IP, every third, when you hire a company that's doing development for you, making sure that they've contributed to the IP, they've signed an IP assignment, and and it's important. And even it goes so far as to what the language in that IP assignment is, which is language that says that I will assign IP isn't sufficient. It has to be a present sense IP assignment. I hereby assign all intellectual property, all right title interest, and all intellectual property, including without limitation, patent, trademark, and et cetera. And that current assignment by everybody is just essential from day one. And I just keep running this over and over again, where people don't do it, and it's creating issues when we get to the finish line.
The most important thing we can convey today is, frankly, thinking about these issues, dealing with them up front. It can save you literally millions and millions of dollars of money and maybe even a loss of rights. It's hard. Again, entrepreneurs are very, very busy people. They're really trying to get things off the ground, but just a little bit of attention to this stuff can pay tremendous dividends down the road.
So, and this is actually a fairly easy one. This is a pretty easy one. This is just making sure that your forms that you have employees or independent contractors sign. And George, am I right that an independent contractor, if it does not have an IP assignment, if somebody writes for you software, and it doesn't have an IP assignment, they're not an employee, they're an independent contractor, I actually don't own it. They do, right?
Yeah.
And I paid them for it.
It's a great point, Dave. Everyone very, very naturally thinks that because you pay someone for something, it's a work for hire and you own it. It is not that simple. There's two ways that something can be a work for hire: an employee in employment context, or an independent contractor can be a work for hire, but only if it's a certain types of works. There's 9 enumerated categories of copyrightable works that can fall within, in essence, work for hire by agreement. Otherwise, it's not a work for hire. But the point remains, you can still have them assign whatever rights they have. You can and should. So whether or not it's work for hire, you still want the assignment.
Yep. So I think I've beat that one to the ground, but it's really important. All right. Other questions on ownership? Okay. A little bit of strategy about, let's go back to patents for a moment, because they're not inexpensive. Give us a sense of what it costs to file a patent.
Well, there's going to be a couple of different categories, right? So you have the fees that you pay to the patent office. Then there are usually fees associated with preparing drawings. Those may be part of your attorney's fees, but oftentimes we hire draftsmen that prepare the drawings because it's just more efficient. And then you have your attorney's fees if you use an attorney. So the filing fees alone, and those also vary depending on the type of entity you are. For most individuals, it's going to come in around $1,000 in filing fees. If you qualify as a micro entity, it would be about half of that. So there's ways that it, but I would say plan on about $500 to $1,000 in filing fees alone. And that's for non-provisional application. The provisional filing fee is a lot cheaper, around, I think it's currently $130 maybe. So it's cheaper, but that's, as we mentioned, it's just a placeholder. It buys you a year, and then you'd have to go forward with the non-provisional filing. And then with respect to the attorney's fees, I mean, that's where the biggest variable can come in. So we, I would say sometimes it's about $5,000 in attorney's fees. That would be the lowest end. And then more often than not, it's about $10,000 to $12,000 in attorney's fees. And at times it's $20,000. It depends on how technical, how technical the invention is and the scope of the claims. It depends on if it's one really discrete invention or if it's a couple of related inventions. So that's why there's the big range. But I would say, that middle 10,000 is a pretty good estimate.
That sounds about right to me. And so one strategy is to file the provisional patent application, which we talked about a little bit earlier, which has some of the benefits that we talked about. And that could be a little less expensive because you don't have to describe all the claims and go through the whole claim process in the provisional. You can, but you don't have to. Right. So some startups take the strategy of filing a provisional patent application fairly early for a little less money. It's not free, but it's a little less money, and then up to a year later, no later than a year later, don't forget, converting that provisional into a non-provisional, and you pay later. And so it's not perfect, but that is a strategy for growth companies.
And going back to the point Reed made earlier, the more the inventors help in the technical description of the invention, the better.
Yep.
They do know it better, Reed. And it's tough to get some inventors to focus. We deal with that all the time. But if they can focus, it will be a better product for sure, and it will save money.
So, but it does cost money. So point one is that is a strategy for patents to reduce the cost, defer some of the cost, and get some of the benefits we talked about of the patent. Another question, however, that should be addressed is, should I get a patent? It doesn't make sense. And that's something that one should think about hard up front. Let me tell you the reason that is not acceptable. You should not get a patent because you think that it helps the company get financing because because it looks better on the website, because it gives credibility to it, patent pending. I think those are lousy reasons from my perspective. There should be a substantive reason as to what you think should be protected and why it should be protected, and why it creates value for the company. I for one don't buy the count the number of patents to add value argument. Reed, you may disagree.
I agree with that, and we spend a lot of time working with our inventors trying to figure out individual situation. Like, does it make sense to file a patent here? Can we just license copyright code, for example, without having a patent? Is there a long-term benefit to this? So in some fields, by the time the patent issues, which could take 3 or 4 years, the field has moved on and it's a worthless patent. Why even do it?
Yep.
I just want to go back to the prior point about the cost. The numbers that Lauren was talking about were the initial filing fees.
Thank you.
That's not the end of the road. I think, as Paul said earlier, the first response back from the patent office is all claims are rejected. And then you engage with your attorney and you go back and forth through these things called office actions, where you try to convince the patent examiner that it should be issued when they've already said no, it shouldn't. And each time you go back and forth, it's another $3,000, $4,000, $5,000. And you could do that process multiple times. Maybe you'll end up with a patent, maybe you won't. You could spend tens of thousands more after the initial filing and still not get a patent. So
which I didn't realize, if I could
keep
add
all
in
that in
there.
mind. But yeah, it's very typical for the first response to say all claims are rejected.
And
And then,
go ahead. Can you guys, and patent attorneys normally, or at least the one I was working with, I mean, wasn't very upfront with the cost on that. I mean, I get it; it's a business, but as a startup, you guys, should you file a patent? And my patent is trying to on a cold brew coffee machine. I would suggest to many startups on there is get closer to selling first, because you don't know where you might need those funds. Like right now, I'm in a kind of a bind because I've already invested thousands into this patent, and now the office action came back, and they want a couple $1,000s more, and it's not even guaranteed that I'll get anything there. And so now these are funds taking away from where I would rather apply those funds. So for anyone out here, I mean, that would be my recommendation for your a startup and you're thinking about it, get a little bit further along first and see where you're going. If you're starting to pick up momentum, then maybe do the patent, because budget's a big problem with startups.
So I agree with you, Paul, subject to the caveats we had earlier about not placing yourself in a position where you're waiving the right to it.
Yeah.
So Paul, did you file a provisional first?
I did file a provisional, waited a year to keep developing the product, then filed a non-provisional.
Okay, yeah.
So we will sometimes tear up the first provisional and file another provisional as long as there hasn't been a publication.
Right.
We can keep doing that as long as there hasn't been a publication, and just keep kicking the can down the road for filing the full application.
Yeah, we did file a couple provisionals, but at the time we were told if you want the filing date of your original provisional, well, you
That's
still
true.
need to file.
Well, that's right.
non-provisional.
Yes,
That's
correct.
true. Yeah,
So
you lose that initial filing date, but you kick the can down the road in terms of incurring more expenses. Once you get on that treadmill, the expenses just keep coming.
And you just don't know that. You don't know that until you, at least for
Yeah.
my sake, you don't know that until you start doing it.
And what Reed didn't even tell you is if it gets worse, because if you're fortunate enough to have it issued, then you got issuance fees, right? That come down the road as well.
Yeah,
So-
those are relatively small in comparison what you've spent to get to that point.
Yeah.
But then you have issuance fees and then later maintenance fees. So the expenses keep coming.
Yeah.
But
And
you
a
can kick them down the
PTC,
road by
which
refiling provisionals.
I
if you have
regret. Yeah, PTC as well. I don't know if you guys were going to talk about that, but they kind of got us on that, which I wish we did too. But we filed a PTC and then end up filing a patent in Canada. But I mean, that's thousands and thousands more dollars. But
Yeah, especially in the context of PCTs and filing in foreign jurisdictions. I mean, the cost can really escalate very, very quickly.
yeah.
But having said this, I mean, just on the flip side of this, a well-crafted patent in the appropriate place can have quite a bit of value. So it's not they're not for everybody, and that's what my point is. You think about it, put it in understand it, understand the implications as Paul points out, and do it in a knowing way early. And I think that's the lesson.
Yeah, so when we're looking at making a decision on patenting, we're looking at many different things. One is like, how significant is the concept here?
Yeah.
Is it a narrow little improvement and there's going to be 20 other narrow little improvements by other people? Not worth it. But if it's a broad concept and it's going to lay out this broad territory and you can exclude other people from doing that, that's a benefit. And as I said earlier, like, how fast moving is the field? So we see a lot of things in the AI space, machine learning space, like, is this still going to be like cutting edge 4 or 5 years from now when the patent actually issues? Or is like the field moves so fast, it's just worthless to have a patent?
It's also published, so people can reverse engineer or do a workaround. So I mean, that's another consideration, I think.
And then in academia, there's a lot of people who are putting things into open source. Like, if you're putting it in open source, we're not spending money on a patent.
Yeah.
But it's a little the monetization of open source. I mean, you can do it, but
You can, but it has to be part of a strategy, not willy-nilly.
right.
And that's the point. Yeah.
And the other thing I would say, we've seen this, I was a member of Blue Tree and an angel investor. And one of the things that we would see, those who get the initial patent, but they don't have an ongoing patent strategy because there are other, you might have touched on this and I kind of missed it too. So even though it's painful to get the first one, that you're going to be subsequent developments along the way that also need to be protected. So again, just get kind of good business advice. I mean, you can get good patents, but it's a question of talking to investors and others who understand the value about
And
what needs to be
Does the
done.
patent cover something that's important to you as a business?
Yeah.
Having a patent that protects a sideline thing doesn't matter. It has to give you a competitive advantage that is important to your business.
Yep, I agree with that 100%. Kit, I think we're at our deadline, right? Alex has a question.
Yeah, I have a question. Because I'm an international student. Currently, I have F1 visa, so I'm wondering, yeah, can I also file file provisional or non-provisional patent as a F1 student? And if the effectiveness of the patent I feel has the same effectiveness as like US residents file.
I could answer, but maybe one of the patent attorneys wants to answer.
I'll give you the first crack at it, because I'm not an immigration attorney either, but
Yeah, it just doesn't matter. Like
It doesn't
anybody
matter.
from anywhere can file a patent in the US, for example.
Right.
It just doesn't matter.
okay, the issue with F1s is you're here on a study permit. You do not have a valid work permit. And so inventing something can be perhaps consistent with your academic workings and idea. But what we don't form a company. You can form the company, but you can't work on your company legally. So we can do a lot to help you around sort of the business that your patent is around. But you can own the patent, you can file it yourself.
Oh, yeah.
Well, and not all countries have the same law as the US. So in the US, you don't have to be a US citizen to file a US patent, but there are other jurisdictions where you have to file in your home country first before you can file elsewhere. So
Okay.
just something to keep in mind.
Do you know
And there
about
are also national security issues potentially, depending on the technology. If someone's from Libya, filing a U.S. patent application, it relates to, some military thing. You have to get permission before you take that back to Libya.
Gotcha. And what about the copyright? Like, can I also like license the copyright?
anybody who writes anything? You get a copyright per se by creating it, whether you want to register or not. I guess your question is more to, can you register?
Yeah.
Yeah. Okay.
You know what? And George, Lauren, you can correct me on this too. You write something at the bottom, you put down on every page or whatever it is, just say copyright protected, used only with permission, copyrighted, only used with permission. You just declare it, right?
Circle C copyright, your name and date of first publication.
Okay.
Okay.
But keep in mind that all of this is subject to what we talked about earlier about ownership.
Yeah.
So depending, are you a PhD student paid on a research grant? Then the university owns it, not you.
Yeah.
It
I see. So for the patent, actually, there's a filing process, but for the copyright, it's just self-declaration. Declare. Yeah.
Both. It's both. You can file or or self-declare.
Okay, got it. Thank you.
On a practical matter, let me just say this too. Once you file it, then you have annual fees or regular fees in order to renew the copyrights.
No.
What I have heard, this is more a business thing in a sense that file it if you actually are going to contest it.
You have to file bring litigation, as Loren said. There are not ongoing copyright maintenance fees.
Oh, they're not. Okay. That's trademarks then, I think.
Trademarks, yeah.
Okay. All right.
And patents.
So what did Loren to file a copyright? What's that cost?
The last I checked, it was about $100. I don't know if George has more information. Does that sound about right?
Yeah, it's a pretty low number, but the question is you got to have all the information to fill the form out correctly, which always takes more than you think. So there's some lawyer fees just in accumulating the information, getting deposit copies. So it's not terribly complicated. So if someone comes to us with everything ready, yeah, it's pretty straightforward. But that doesn't usually happen.
Gotcha. Thank you so much.
Our pleasure. Okay, I think we're coming near the end of our time.
I
Can I
believe
make
so.
one
Just a-
call out for help if possible? Just trying to see if there's any chance at some point, not right now, if someone's willing to talk to me, just best advice moving forward with the situation I'm in. Yeah,
Sure.
obviously, if anyone's willing to do that, just trying to see.
Sure, we'll brainstorm with you. Send George, Loren, me an email, and we'll chat.
Okay.
Happy to do that.
Awesome. Thank you.
Yep, absolutely, certainly.
Okay.
Cool.
So again, this is recorded and will be available on the Pitt website and ultimately in the CMU, what we call the website with the archive section, and within a couple days. So can we thank our panelists?
Yes,
So
thank you.
that was excellent. I
Very
thought,
good.
okay, thank you.
Thanks, team. Thank you.
Okay.
All right. Good night, everybody.
Have a great evening.
Okay,
Thank you.
The next one is on company formation. And that's at the end of October, part 1, and then part 2, there's a workshop where we team you with all students to actually come up with a roadmap on if you're going to do company formation to give you guidance on what would be the best structure for your startup.